The instant case having peculiar facts and circumstances, namely, after 10th August 1968 the lease stands terminated by efflux of time, which is further evidently clear from the termination notice dated 1st September 1972, and thereafter, the original lessee becomes an unauthorized occupant in terms of Section 2 within bracket G of the public premises within bracket Eviction of Unauthorized Occupants Act 1971, and consequently not entitled to deal with the property in question in any manner. The very concept of conversion of leasehold rights to freehold rights is not applicable to the fact situation. The profits or gains arising from the transfer of a capital asset by a person to a firm or other association of persons or body of individuals, not being a company or a cooperative society, in which he is or becomes a partner or member, by way of capital contribution or otherwise, shall be chargeable to tax as his income of the previous year in which such transfer takes place, and, for the purposes of Section 48, the amount recorded in the books of account of the firm, association or body as the value of the capital asset shall be deemed to be the full value of the consideration received or accruing as a result of the transfer of the capital asset. Capital gains is artificial income. It is created by Act 1961. Profits arising from transfer of capital assets are made chargeable to income tax under Section 45 within bracket 1 Act 1961. From the scheme of Act 1961, it is clear that capital gains is not an income which accrues on day-to-day during specific period, but it arises on a fixed point of time, namely, on the date of transfer. Section 45, in effect, not only defines capital gains but makes same chargeable to income tax and allots appropriate year for such charge. It also enacts a deeming provision, namely, deemed income which arises at a fixed point of time, i.e. on the date of transfer. Having said so, court proceeded to observe that in general sense, the expression transfer of property connotes passing of rights in property from one person to another. In one case, there may be a passing of the entire bundle of rights from the transferor to the transferee. In another case, transfer may consist of one of the estates only out of all the estates comprising the totality of rights in the property, and in a third case, there may be a reduction of exclusive interest in the totality of rights of original owner into a joint or shared interest with other persons. An exclusive interest in property is a larger interest than a shared interest in that property. To the extent to which the exclusive interest is reduced to a shared interest, it would seem that there is a transfer of interest. Therefore, when a partner brings in his personal asset into the capital of the partnership firm as his contribution to its capital, He reduces his exclusive rights in the asset to shared rights in it with other partners of firm.